Sentiamo il segretario regionale che ti racconta come arriva
Okay, distinguished guests, EIF members and friends, a warm welcome to you all for today's debate on copyrights in the EU digital single market. A special welcome goes, first of all, to our colleagues, MEPs, who are here with us. Some others will probably join. I see Julia Reda, Timo Völken, and obviously Catherine Stihler, which I will mention later, that is co-chairing this wonderful debate and has been the driving force for this, I hope, a very good occasion for exchange. Obviously, a special welcome goes as well to our speakers. I will introduce them in a moment, but let me just say a few introductory words. I will be brief because I think it's important that we have a real debate. As you all know, the reform of EU copyright rules has been a long-running and hotly debated topic within the European institutions. The extensive proposals for reform will have consequences for a whole range of stakeholders within Europe. And today we will focus in particular on the copyright reform in the context of public interest, consumer protection, and impact on citizens, looking at Title 2 and Title 3, so Articles 3 to 6 and 7 to 9. These aspects of the reform are relatively less debated compared to the primary focus that, for some extent, has been placed on Articles 11 and 13, yet they will affect sectors that are crucial for our societies, such as education, research, and culture. So to update the copyright framework of digital content and cross-border use, which have been both become central in all these fields. Therefore, I am particularly glad that the colleague Ms. Stihler chose with us to focus the debate on these aspects in order to amplify the voices of the relevant stakeholders for these two titles of the reform also. As I said, a bit less on the spotlight than Article 11 and 13, but extremely important and issues where colleague Stihler has been doing a very important and relevant work. Our distinguished speakers all have hands-on experience with copyright in their daily work. Therefore, I'm sure they will provide us with precious insight on the impact of the reform. As you know, we have been working on the text as a parliament for around 2 years now, and since the jury vote has not taken place yet, there is still some room for reflection. I will briefly name just a few of the points I think are mostly worrying and as it stands, and they should be, in my opinion, still debated. First of all, we need to be careful about the scope of the exceptions regarding text and data mining, which are risk to be too narrow and risk hindering innovation at the EU level by excluding the startups, independent researchers, journalists, etc. I myself co-signed several amendments on this topic in both IMCO and jury, asking to broaden the scope of the exception, as well as not to limit it to the sole purpose of scientific research. As for the digital use of copyrighted works for the purpose of teaching, including only educational facilities and only limiting the exception for non-commercial use, also leaves out other research and cultural heritage institutions that might provide other types of educational activities and non-formal education, something I've been working very much as co-chair of the Youth Intergroup in the European Parliament. The same stands for the article on preservation, as it is only limited to this act and not to research, educational, cultural activities. In general, I would say that rigidity and narrowness are naturally opposed to culture, the spread of knowledge and research. That is why we need to find the best solutions that then contemporate different interests that obviously are there and must be taken into consideration to find the best solution. As the time is limited, as I said, I don't want to delve more into the details, but I'm sure that we will hear a lot from our speakers. I hope then after their presentations there will be time for some exchange of questions and answers. I will list them in the order we ask them to present their views. First of all, we have William Bowes, Director of Policy and General Counsel of the Publishers Associations, probably especially on text and data mining. We will hear from him. Then Rosa Maiello, National President of the Italian Library Association, which advocated pluralism and freedom of expression through her work. So probably going on also on the cultural heritage issue. Julien Roche, Director of the LILLIAD Learning Center Innovation of the Université de Lille. For sure, we will hear on research and teaching. And then Anne-Marie Beunen, copyright lawyer, National Library of the Netherlands, probably on all these topics. So thank you for coming, and the floor is yours. Thank you.
Well, thank you very much for the introduction, and it's wonderful to be here today. I'm going to use a little bit of the time I have to tell you a little bit about me very briefly, so you understand my perspective and where I'm coming from. I am Director of Policy at the UK Publishers Association. I've been in this role for 3 weeks. Up until Christmas, I was General Counsel of Cambridge University Press, and I want to talk a little bit about the perspective that provides to publishers and to publishing on the issues that you're all discussing today. Cambridge University Press is the world's oldest publisher, founded in 1534 by the original Brexiteer, Henry VIII. And this means it was around a very long time before copyright existed, and so it's an organisation that understands being a publisher in both contexts. And also as an employee of the University of Cambridge, one of Europe's leading universities, the discussions we had internally about how to make this framework work for all parts of the academic community were long, very, very, very difficult at times, but we had a real interest in making it work for all the different communities. And so I want to bring some of that experience to bear today. But I also want to talk a little bit about Europe and European values and publishing values. I have a passport here. It is red, not blue. This means I am European. I have a business card which says that I'm a publisher, and the values of both, I think, are very related and very tied. We believe very much in free speech in this community. We believe very much in culture, knowledge, learning and research. We want to live in a community where we educate and inspire our young people. But also, we live in a community where a single market and trade has brought down barriers, has created understanding between communities, and has secured peace and prosperity throughout this continent. And as we all know, single markets and trade rely on property rights, and they rely very strongly on the rule of law. And in a polarized world that we find ourselves in, where people to our east are questioning whether we can have free trade but no free speech, and people to our west are questioning whether we can have free speech but with protectionism and less free trade, Europe has an opportunity to stand up for both and communicate its values at a very important time. But with rights comes responsibilities, and I hope that this is the second thing that we can agree on today. But what are the responsibilities of publishers? This is something that we hear politicians talking about frequently now in an age where we talk about online dissemination of content. What are they? Well, first and foremost, they are to encourage learning, and I will come back to that in a minute and why that's important. Secondly, they are to produce and maintain quality content, so make sure it's accurate, truthful, up-to-date, and useful for the purpose that it's required. Thirdly, at the core of our being is the provision of access, and enabling people to have access to content, to have access to knowledge, learning, and research for whatever purpose they need that content. But access is at our core. And fourthly, it's to be fair to the rights of others, whether that be to respect privacy, whether that be respect via the laws of libel and people's reputation, or whether that be to respect their property rights. These are the core things that publishers believe in and respect. But what framework do we have to operate within? Well, we have copyright. The world's first Copyright Act in 1709, its full title was actually an act for the encouragement of learning. Copyright has been encouraging learning for over 300 years now. That is its core social purpose. It created private economic rights for a public and a social purpose, and it has been achieving that purpose continuously throughout that time. And when we're thinking about policy making in this area, we have to remember why it was created, what it was set out to do, and make sure that that core purpose continues. Of course, as publishers, we know there must be exceptions and limitations to copyright. We do not believe it's a perpetual monopoly right. We understand the role that exceptions play in achieving the social purpose of copyright and the rights that governments have given us to do our work. But they must be certain, and they must be carefully crafted, and they must allow us to achieve a balance. And of course, balance is at the heart of the question that we have here today and the one that was posed to me. But balance of what? It is assuring a balance between use and access on the one hand, which is today's debate, but also the production and supply of quality content on the other. That is the true balance that we're seeking. Because if we focus too much on use and access, we do not have the production and supply. So keeping those two things in balance is absolutely important. And I would also ask you to remember that exceptions do not remove cost. They do not make content free. They merely move it to another place. So if you make exceptions too broad and you make content free to a user, someone somewhere is paying to create and develop that content. There is no such thing as making it free. And the question we have to ask ourselves as a community and a society is, who should pay? Where should that cost sit? And this matters particularly for educational and academic works, because many discussions around exceptions rightly focus on academic and educational works and academic and educational publishing. But if you are an academic and an educational publisher, and the only purpose for which you invest and create your work, and the only market you have for that work is the academic and the educational space, and you are not able to charge for that, then how can you possibly employ people to create that content in the first place? This is very different from other content sectors where education may only be a partial part of their market and their use. But for academic and educational publishers and works, this is all that we have, and it is all that we do. In other words, if we create exceptions that are too broad, we jeopardize the creation and supply of the very thing that is most important to those people wanting those exceptions. So what is the way forward? Well, we have ongoing negotiations around the new law, but I would ask more broadly, both during that process and after, that we talk to each other more and we understand. That is why I'm here today in Brussels. I hope you all leave learning a little bit more about publishers and I leave learning a little bit more about you. But let us work together to increase access and use and around licensing, with licensing and not legislation. Let us use technology to develop tools to find content better and also its parents to avoid the issue of orphan works. Let us cherish our creators and all who help them in the content industries. Let us support our teachers, inspire our children, fuel research, and create a better Europe. Because together we can tell Europe's story to the world. Je suis un éditeur, je suis une Européenne, je suis très fière des deux. Merci.
Good morning. Europe had the duty to be an example of democracy and respect for human rights. Simone Weil. This is a sentence out of this parliament. That's what European libraries are for. They help bridging cultural gaps and protect cultural diversity. In the digital environment, their role should be enforced to overcome digital divide and inequality in learning. The digital library serves as an environment to bring together collections, services, and people in support of the full life cycle of creation, dissemination, use, and preservation of data, information, and knowledge. This sentence is from the IFLA UNESCO Digital Library Manifesto and is part of the Millennium Program of the UNESCO. From the viewpoint of fundamental rights, which are related to preservation and reproduction of humanity, the legislation on public libraries and legislation on exclusive right of owners on copyright are within the same framework. Their aim is cultural promotion, freedom of expression. But in the digital environment, the exclusive rights of copyright owners have assumed a preponderant influence on library collections and services. Never in the past we have had to face a lot of uncertainties, transaction costs, to negotiate licenses which are very different one from another. We think that a good copyright framework, a good legislation on exceptions and limitation could be the necessary base to encourage the market in provide licenses which are suited for user needs. And the EU strategies until now for digital libraries mainly rely on non-binding measures, recommendations, incentives, while the exclusive rights have been enforced and enlarged. This is the problem, on our opinion. As a result, libraries face complex negotiations to obtain licenses that often are not fully satisfactory. So we welcome this directive proposal, which have been waited from a long time, and raised great hopes in libraries and their users. But we would stress some issues. It could be ameliorated, and we hope that the attention of MEPs will be of support. On Article 7 to 9, out of commerce work, we think that the definition of out of commerce works is too narrow. We think it should include translations, works which are not more available, works which never were in commerce. Also, those works should be included. Of interest for the market, but are of great interest for culture. We stress also the problem that we think there should be a time limit after the right holder have been informed that the work is defined out of commerce. After this time, as in civil law normally, the work should be considered stable, there should be not a reversibility of this status. We think all of you should share the need of preserving cultural heritage, and we think that also digital content licensed, subscribed by libraries should be under this exception. As to the illustration of teaching and TDM, text and data mining, we think that it should be the purpose of the utilization, not the institution which put it in place to make the difference. And we agree with EBLIDA, IFLA, and other library associations on the point that libraries are learning environments. So there are programs for informal learning should be included in the provision of this exception. As to text and data mining, we are worried that an enforcement of limiting in an excessive limiting of the text and data mining could hamper a lot of utilization in the public sector, for instance, very helpful. Research are not made just in universities or in advanced centers. Also, the public sector, public administrations could improve their analysis of facts and data to take decision, and so on. Then there is something which is not in this directive and which we hope will be included. Document delivery, an exception allowing the exchange of reasonable parts of works for research needs, and the e-lending, as you know, as you probably know, there was a judgment who recognized the full legitimacy of a utilization made by a user at a time and for the purpose of personal study. I repeat, licenses are good in a market where the rules, the basic rules, are fair and balanced among all the actors. Thank you.
Dear Mrs. Stihler, MEPs, ladies and gentlemen, thank you for giving me the opportunity to talk about the needs of higher education and research in the context of copyright reform. Many changes will take place regarding copyright in Europe thanks to the reform. I will not tackle all issues, but I will focus on my field of expertise, text and data mining, and explain why this aspect of the copyright reform is so important for the future of European research. So why is higher education and research concerned about the copyright reform? Because the future will be heavily innovation-driven. We all know the huge ambition of Europe regarding innovation. European leaders do consider that the future will be intensively innovation-driven. And de facto, the most innovative companies are currently in a leadership position in Europe and the world. Universities do develop ambitious strategies nowadays to support research and innovation. Last but not least, innovation is more and more collaborative. No company, no university is able to innovate alone today. Public and private sectors need to collaborate more than ever. And text and data mining is a powerful way to achieve disruptive innovation. So what is TDM? Europe is giving a pretty long definition of what is TDM. Let's make it simple. TDM is just another way to read, machine read, in order to be able to get access to huge amounts of resources and content. What does the research community expect? In fact, TDM is leading to major scientific innovation. A number of studies indicate nowadays that TDM can increase the efficiency of research, increase coverage of literature reviews, cut down manual work, automate information retrieval, accelerate discoveries. The scope of TDM is including each and every field of research and economical development. All fields of research will benefit from TDM. Let's imagine the near future. We will feed computer with large amounts of literature in order to help artificial intelligence learn languages and develop better translation systems. We will build large databases with medical case studies harvested from scientific literature to help research in the fields of rare disease, for example. We will look for systemic correlations between facts and economical changes, mining large databases publicly accessible. And why do we need TDM? Well, at the moment, we produce each day 2.5 quintillion bytes, meaning 2.5 hard drive disks, just like the one you have in your computer, every day. We produce 2.5 million scientific articles per annum. So it means that 0, it's the number of researchers that can keep up nowadays. We definitely need disruptive methods, and TDM is one of them. What is the problem with the current EU legal context? Let's give a citation from a recent publication. Quoting, academic studies have shown that countries in which academic researchers must acquire the express consent of right holders to conduct lawful data mining exhibit a significantly lower share of data mining research outputs. Relation again, the European ecosystem for engaging in text and data mining remains highly problematic. The end result, Europe is being leapfrogged by rising interest in other regions, notably Asia. So what do we expect? We expect a simple, clear, full, and European-wide exception for text and data mining for research to be able to mine content lawfully accessible. We believe that the right to read is the right to mine. Let's repeat it because it's very important for us. The right to read is the right to mine. 3 barriers need to be overcome: uncertainty, fragmentation, restrictiveness. If you want to have much more details regarding that, there is a European project, Future TDM, with giving much more details about these barriers. So the road is long to embrace TDM. To achieve that, we need to start with a convenient legal framework. That's the EU directive regarding copyright. So what needs to happen? We need first to communicate legal provisions for TDM with certainty and clarity. The copyright reform is central regarding that issue. Researchers need to know what they can and what they can't do with absolutely no ambiguity. Research does not care about national boundaries, especially in a digital world. We need a common and mandatory legal framework for all Europe. Optional exceptions at a national level are nothing but a burden for the research community. We need to clarify the exception scope, where public researchers collaborate with commercial partners. Research is collaborative nowadays. Universities between themselves, but far more important, universities with private companies. Research and economical development are deeply linked. Universities are creating startups, innovation, and added value. So the EU directive has to be an enabler to support collaborative research and economical development driven by research. We need also to let the researchers do their research with as little impediment as possible. The exception for TDM must not be weakened or blocked by any technical measure, such as TPMs. The exception for TDM must not be limited by APIs imposed by publishers. No content provider should try to tell the research community what content they should mine and how they should do it. Researchers want to build their own mining strategy. But it's also good to monitor the interaction of the copyright exception with other relevant legal regimes. Publishers and content providers can provide tools for the research community to mine content, as long as researchers are free not to use them. Advanced TDM services and clauses can be included in licenses as long as the exception is not overreadable. So thanks for listening, and let's make TDM a reality in Europe.
Thank you very much for the invitation to speak here today. The National Library of the Netherlands, where I work as a copyright lawyer, is involved in large-scale digitization in many ways. On the one hand, large part of our collection that are out of copyright are being digitized in cooperation with external parties like Google. And on the other hand, we digitize lots of in-copyright works ourselves. In order to be able to make these works available online, we in the Netherlands are already clearing copyright via self-regulation in a way that is now being proposed in the DSM directive. The Articles 7 to 9 on out-of-commerce works involve collective management organizations that can legally conclude license contracts for both their members and non-members. This is very similar to our contracts with collective management organizations who provide us with an indemnity for non-members. These non-members are thus entitled to a license fee in the same way as CMO members. The license fee is of course modest since it reflects the non-commercial character of our online use of out-of-commerce works. In October 2015, the Dutch government announced that it will give these CMO contracts in the Netherlands a legal basis by introducing ECL in Dutch legislation. The bill has since put on hold, awaiting the DSM right holder of every work. Is impossible, where on every page there could be 5 or more works, such as articles or photos, some of which may well have been created by freelancers who have kept their own copyright. This newspaper example derives from our own library practice. We have a website called Delver, in which we make Dutch newspapers, books and magazines available. Around 3 million newspaper pages on this website are still in copyright. And please note that these Dutch newspapers also include works by non-EU nationals, such as photos made by international press agencies. Given these large numbers, I would like to stress that we really desperately need a solution for this problem in EU law. A collective licensing solution, as proposed by the European Commission, will solve this issue for many institutions, including our library, but it will not work in countries or sectors where there are no representative collective management organizations. To provide a solution that works across sectors and across all of Europe, we need a fallback solution in the form of an exception. Moreover, given that the out-of-commerce articles should be workable in practice, let me give you some suggestions for improvement. First, the out-of-commerce definition in Article 7, paragraph 2 is difficult to work with, as it requires that works cannot be reasonably expected to become commercially available again. This part of the definition is too vague and too subjective for inclusion in a definition. Because, well, who can reasonably expect which work will ever get a reprint? As for our newspapers, this out-of-commerce definition is problematic in that we simply do not and cannot dispose of a list of all the articles, photos, works, cartoons, etc. that are included in all these millions of pages. A per work or out-of-commerce check is thus unfeasible, and there may thus be a chance that some photos, for instance, may still be in commerce. The fact that our library does not have such a list may also be problematic in view of the publicity requirements the DSM proposal imposes. After a cultural heritage institution concludes a license with a CMO on out-of-commerce works, information that allows the identification of these works must be published first before they may be digitized and made available online. The relevant Articles 7.3 and 8.2 seem to oblige cultural heritage institutions to publish such identification information on a per-work basis, which is however impossible for large-scale collections, such as newspapers, which contain an enormous amount of unidentified works. Another suggestion I have for these 2 articles is to delete digitization in both. The publicity requirement should not be able to delay digitization activities, given that digitization may well be legal on the basis of a copyright exception, such as the dedicated terminals exception, as interpreted by the European Court of Justice in its TU Darmstadt decision. And finally, some suggestion on the text and data mining, Article 3. Digital humanities researchers are very interested in performing text and data mining on our newspaper content. A mandatory TDM exception is by far to be preferred over having to negotiate permissions with all the right holders. This exception should preferably also permit libraries to make reproduction for TBDM purposes on request of their patrons. Via libraries, researchers enjoy legal access to a great many publications by way of license contracts between a library and publishers, or on the basis of exceptions, such as the orphan works exception. Researchers will therefore ask libraries, rather than publishers, to provide them with reproductions for their TBM purposes. Libraries should thus be permitted to do so on request under the TDM exception. Should also become publications. Eblida, IFLA, CNL, public libraries enjoy only minimalistic lunches.
Thank you to our speakers, William, Rosa, Julien and Anne-Marie. Thank you so much for your contribution. I think that gives us a lot of food for thought. And as I'm saying food for thought, I'm seeing you all eating. So we have, I think, about, what's the time just now? Can anybody tell me the time? What time is it? 1:20. So we've got the room until 2 o'clock. Brando has to leave. He's got to go to another meeting, and I've got to go to the IMCO working group at 2 o'clock. So we've got time for questions. So who would like to ask our speakers any questions? I'm sure there is. There's some roving mics. So who would like to start first? I'm looking around the room. I'm sure there are some people who would like